Welcome to Casa Academy Chapter 11, Part 1, where we will cover real estate contracts. I'm absolutely thrilled to be your mentor today. We're going to be tackling what is honestly one of the most vital components of your entire real estate education.
Here at Casa Academy, we place a massive, and I mean absolutely massive focus entirely on contracts. And you might be wondering, why the obsession? Well, because contracts are literally the foundation of nearly every single transaction you're going to handle. Grasping this stuff isn't just about checking a box to pass your state licensing exam, though it's absolutely essential for that. It is a critical, non-negotiable requirement for safely and successfully practicing out there in the real world.
Okay, let's dive into this. Our roadmap today covers contract basics and requirements, important statutes to know, offers versus enforceable contracts, types of real estate contracts, and finally, your role and limitations.
All right, kicking things off with Section 1, Contract Basics and Requirements.
So what exactly is a contract? At its core, it's really just an agreement between two or more parties that creates an obligation to either do something or, refrain from doing something. But here's the catch. While every contract is an agreement, the law requires some very specific elements to be present before it actually becomes legally enforceable.
For that simple agreement to transform into a rock-solid, valid contract, 4 specific things absolutely must happen. First up, it needs a lawful purpose, so no illegal deals here. Second, you need a meeting of the minds. That basically just means there's a clear offer and a clear acceptance. Third is consideration. And fourth, you gotta have competent parties, meaning everyone involved is of legal age and has the mental capacity to sign.
Let's zoom in on that third point, consideration, because we actually have 2 categories here. Valuable consideration typically involves money, or at least a firm promise to pay money down the line. Good consideration, on the other hand, involves intangibles, things like love and affection. And hey, while love and affection are totally recognized by the law, they definitely aren't going to pay your broker fees, right? So valuable consideration is absolutely what you'll be dealing with most in your career.
Moving right along to Section 2, Important Statutes to Know.
Now, what's really interesting about this next part is that it's a classic exam trap, so definitely grab your notes for this comparison. You do not want to mix up these 2 statutes. The Statute of Frauds determines exactly which agreements must be put in writing to be enforceable. In direct contrast to that, the Statute of Limitations determines how long someone has to actually enforce a contract through the courts. So, simply put, one governs the format, the other governs the time frame.
Focusing strictly on the Statute of Frauds for a second, this rule actually dates all the way back to English law. It was designed to prevent fraudulent, fake claims that a contract exists when, well, it doesn't. Now, oral agreements aren't necessarily illegal, but if you want them to hold up in a court of law, things like real estate sales contracts, leases longer than 1 year, option contracts, deeds, and mortgages, those absolutely must be written down.
Okay, now for the statute of limitations. Notice the sharp contrast in these legal deadlines. For oral contracts, which you'll often hear called peril contracts, the time limit to enforce them is exactly 4 years. But if you've got a written contract, you get a 5-year limitation period. Knowing these exact numbers is absolutely crucial. You definitely don't want you or your client losing the right to enforce an agreement just because the clock ran out.
Before we leave all these legal rules behind, just a quick reminder to carefully review the additional disclosure requirements in your course materials as you keep moving through the chapter. We're talking about topics like rate on gas, homeowners associations, and energy efficiency ratings. These are all mandatory disclosures, and trust me, they carry some pretty heavy legal weight.
All right, shifting gears to Section 3, offers versus enforceable contracts.
So, an offer is simply a proposal. It's an invitation to create an agreement. But the critical thing you really need to understand here is that it does not become a binding contract until it is fully 100% accepted. So when you're looking at transaction files out in the field, an offer might just be sitting there pending, meaning it hasn't yet morphed into a legally binding reality.
But what happens if that offer never actually makes it to acceptance? Well, an offer can be terminated by withdrawal, rejection, or just a lapse of time. Also, your verification code is 159788. Other ways an offer ends are the death or insanity of either party, or, the actual destruction of the property. Any of these events will stop an offer right in its tracks, before a contract is ever even formed.
Conversely, once a contract is actually formed and legally binding, it terminates in completely different ways. Ideally, it ends through performance, which just means everyone did exactly what they promised to do. But it can also end through a breach, revocation, renunciation, a lapse of time, or abandonment. And keep in mind, depending on the circumstances, improperly walking away or terminating a contract might lead to a party being liable for some pretty heavy damages.
Let's move to Section 4 and see how this builds. Types of real estate contracts.
One of the very first contracts you're going to encounter out there is the listing agreement. You can kind of think of this as an employment contract between a seller and a broker. Now, the broker isn't guaranteeing that the property will sell. Rather, they're agreeing to make reasonable efforts to market and sell the property in exchange for compensation. And while there are a few types out there, the exclusive right of sale listing is by far the most common one you'll see in residential real estate.
Next up, we have unilateral contracts. These are a little different because they're binding on only one party. A classic example of this is an option contract, like a lease option agreement. In this kind of setup, the property owner, known as the optioner, is legally obligated to sell if the tenant actually chooses to exercise their option. However, the tenant, the optionee, is completely free to just walk away. They are under absolutely no legal obligation to buy.
In direct contrast to that, we have bilateral contracts. These are agreements that are binding on both parties. A standard real estate sales contract is literally the perfect example of this. Both the seller and the buyer have mutual legal obligations to perform. The seller absolutely agrees to transfer ownership, and the buyer absolutely agrees to pay for it according to the exact terms. It's a two-way street.
And finally, that brings us to Section 5, your role and limitations. Here is a very firm reminder from the course material and honestly just good life advice. As a real estate licensee, you are not an attorney. You are not licensed to practice law. Your legal authority is strictly limited by law and regulation. So if you ever encounter a contract situation that you don't fully understand, and trust me, you will, always work within your authority and consult your broker or a qualified legal professional. Taking that one simple step prevents incredibly costly legal disasters.
I also need to give you a quick warning about maintaining your hard-earned credential. You absolutely must complete your post-license education on time. This required education is going to expand greatly on these exact practical concepts. If you fail to complete it, you risk losing your real estate license entirely. Literally, the whole shebang. So make sure you stay completely on top of those deadlines.
So the crucial point is, contracts form the absolute bedrock of what you will do every single day. Let's do a quick recap. Remember the 4 valid contract requirements. Make sure you know the difference between the Statute of Frauds and the Statute of Limitations. Understand exactly when an offer transforms into an acceptance, the difference between unilateral and bilateral contracts, and of course, your own professional limitations.
And that brings us to the end of our explainer today. So, what does this all mean for you? Are you ready to apply these contract fundamentals to protect your future clients and actually succeed in your real estate career? Mastering how contracts are created, enforced, and terminated, well, it isn't just about passing an exam. It is about empowering yourself to be a highly competent, incredibly successful professional. Keep studying hard, stay curious, and you'll be ready for whatever comes next.